attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series discussing NASDAQ listing requirements. All NASDAQ companies are required to comply with stringent corporate governance standards. The categories of corporate governance include distribution of annual or interim reports, independent director requirements, an audit committee requirement, a compensation committee, a nomination of directors committee, a code of conduct, requirement that the company hold annual meetings, a requirement that the company solicit proxies, quorum requirements, conflict of interest standards, shareholder approval standards, and voting right requirements. This LawCast provides a brief highlight of each of these corporate governance standards. In the next LawCast in this series, I will discuss the independence requirements for the independent directors. A company must make its annual and interim reports available to shareholders, either by mail or electronically through the company's website. The company's board of directors is required to have a majority of independent directors. The company is required to have an audit committee consisting solely of independent directors who also satisfy the requirements of SEC Rule 10A-3 and who can read and understand fundamental financial statements. The audit committee must have at least 3 members. One member of the audit committee must have experience that results in that individual being financially sophisticated. The company is required to have a compensation committee consisting solely of independent directors and having at least 2 members. In addition, there are additional independence tests associated with the compensation committee members. The compensation committee must determine or must recommend to the full board for determination the compensation of the chief executive officer and all other executive officers of the NASDAQ listed company. The nomination committee of the directors must be independent and must select or recommend nominees for director roles. The company must adopt a code of conduct applicable to all directors, officers, and employees. The company is required to hold an annual meeting of shareholders no later than 1 year after the end of its fiscal year end. The company is required to solicit proxies for all shareholder meetings. Quorum must be set at not less than 33 1/3 of the outstanding shares of the voting stock for any meeting of the shareholders. The company must conduct appropriate review and oversight of all related party transactions for potential conflict of interest situations. The company is required to obtain shareholder approval of certain issuances of securities, including acquisitions where the issuance equals 20% or more of the pre-transaction outstanding shares, or 5% of the more of the pre-transaction outstanding shares where a related party has a 5% or greater interest in the acquisition target. Issuances resulting in a change of control. Equity compensation issuances. Private placements where the issuance equals 20% or more of the pre-transaction outstanding shares at a price less than the greater of book or market value. Finally, corporate actions or issuances cannot disparately reduce or restrict the voting rights of existing shareholders. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.